Laurie, and I'm a senior home coach. And what I do is I help families and seniors in transition to make it as smooth as possible. And this would be what would be involved is moving into the next home. Today, I'm excited that to inform you that I am talking to Christopher Davis. He is an attorney with Davis Law Firm. And he's going to talk about the purposes and uses of a power of attorney. So take it away, Christopher.
Morning, everybody. Just a little background. I'm an attorney in Rochester, Minnesota. I'm licensed in both Minnesota and Wisconsin. I've practiced in Southeast Minnesota for about 25 years in the estate planning arena. So, for those of you, a little bit more background information, that means wills and powers of attorney, trusts. We do guardianships, conservatorships, probates as need be, trust administrations, etc. So powers of attorney are something that we use day in and day out. There are a variety of different types of powers of attorney, so we're going to kind of narrow it down a little bit for our discussions today and just simply kind of focus on the most common type of a power of attorney, which is often referred to as a durable power of attorney. And we use durable powers of attorney in a variety of different measures and means. A durable power of attorney, in a nutshell, is when someone creates a document that appoints someone else to help them make their financial decisions if they are unavailable. And unavailable could be as simple as they're not present to complete a transaction, or it could be that they're incapacitated. So, using an example, if we have a traditional family situation where you have two spouses, and one spouse is traveling, if you had a power of attorney, that other spouse then could, for example, sell a house, or they could withdraw money out of an account if it was in the other individual's name. And of course, if there's an incapacity issue, which means that one is unable to act, and in that scenario, that's when a power of attorney is very valuable because it allows the person that you've appointed, your trusted individual, that is often referred to as the attorney in fact. That's the legal title. They're not an attorney, but rather it's just simply an individual who you've appointed to manage your financial affairs. They're able to access your accounts, whether it's a bank account, an IRA, or 401k, or 403b, to pay your bills. And what we often run into in scenarios that I have laid out is if we have two spouses, you have to understand that it's just because you are married does not mean that you have the legal rights to the other person's access to their assets. So, for example, if you have somebody who has a 401k or a 403b, if that spouse is incapacitated and we don't have a power of attorney, then we'll end up having to go to court and have a conservatorship established so that you have the legal right to do so. And the power of attorney circumvents that process. It allows you to do that immediately. So often when we sit down with a family, we will
How
go.
long can that take, Christopher, when it comes to the conservativeship?
It depends on what exactly we're doing, but we're talking several months.
Okay.
So if we have a spouse who's in a car accident, they're incapacitated, and we need to access their 403b account. The first thing that we have to do is we have to get a physician statement that declares them this is their condition. Then it's filed with the court, and we then have to notify any interested parties, and then we will have a hearing during that time frame, and that we're probably talking minimum 60 to 90 days, unless it's an emergency. An emergency means we have an acute need, and that acute need could then circumvent that time frame. We can get one fairly shortly, but then we still have to go back to court to have it formalized later. Okay, so it's as I have laid out there, you can imagine when you hear court and you hear hearings, right? You're talking money, right? It's going to cost money. And a simple power of attorney can prevent that from happening. Does that make sense?
Makes a lot of sense to me.
Yeah. So what we will do is with our families, we will make sure that if we have two spouses, that each one has a power of attorney for the other party. They're usually the primary, and then we actually have backup individuals who will step in the event that, say, both of them are in a car accident.
Mm-hmm.
Right? And then that individual can step forward and manage the assets. And when you have a situation where, say, somebody has a trust, where the trust is managing the assets, there's always going to be assets that are held outside of the trust. And I keep using references to any of the retirement accounts. You're not going to title a 401k or a 403b into your joint revocable trust. And the reason being is because that would be viewed as a taxable event by the IRS. So instead, we keep those assets outside of the trust, and we use a power of attorney to manage those assets. So you can have a scenario where the trustee is also your attorney in fact, right? And depending on the type of asset, they put on the different hat that they need that day, right? That's kind of how we usually set it up. So if your trustees and your power of attorney are the same people, they're just putting on the hats as need be.
Great. Thank you so much. Did you
Yep.
want to add anything else, Christopher?
One thing that I would point out is that number one, when someone dies, that power of attorney terminates the moment that they pass away. Okay, so you cannot use it after someone is dead, right? The power of attorney is only good when you're alive. So, like, if you have a will, your will's only good when you're dead. Okay, it doesn't do you any good when you're alive. That's your power of attorney that does helps you with your day-to-day financial matters. Okay, but it does not deal with healthcare matters. Right. So if you have a scenario where you're looking for someone to help you with your making your healthcare decisions, then you're going to look for, in the state of Minnesota, we call them healthcare directives. Okay, so you would have a power of attorney will deal with our financial matters, and your healthcare directive will deal with your health issues. Okay, so you want both of them. But when getting back to my original point, when someone when the principal, the one who created the power of attorney, passes away, then that attorney, in fact, no longer has the authority. And you actually, if you have a will, you end up having to have go through the probate process, and your executor, or what we call the personal representative, is then appointed, and they manage the money thereafter. Okay, distribute out the assets, pay off any outstanding expenses.
Okay.
Mm-hmm.
Gosh, it's so important to have that power of attorney then.
It is very important. In my mind, it is one of the most important documents that you can do in advance that will help you along the way. It's also one of those things that you want to make sure the people that you are listing on as the attorneys, in fact, are people that you can trust, and you also want to have the ability to look at what they're doing and have other people look at what they're doing, kind of do a check and balance, because you can have situations that don't turn out so well if somebody's accessing your funds, right?
Okay.
Mm-hmm.
Well, thank you so much.
Well, thank you for having me.